Ashwarya, the background noise at your end or Slide's end? Some construction is going on, I guess.
At Lalit's end.
Okay, okay.
Uh, I will just mute. I was trying to add a
Virtual background.
virtual background. Yeah, I was
So,
looking for a picture.
are you able to do it or shall I help you? It's under
No, no,
settings.
I found. I'm just looking for
Okay,
the
okay,
image.
okay. I was just having a discussions with Krishna and Akars on okay, what are the real challenge which in the Indian market now, no, after this laws will be there, will be facing. So we know on high level a lot, but just wanted to collect real problems. So one of things which we found was how the significant data fiduciary is gonna be responsible, who will be, what are the details around it. So that was one of the things which we found. Okay, it's still very ambiguous. So who will become?
So Imanshu, you'll have to give me a minute while I set up my background. Yeah.
Take your time. Take your time. But Ashwarya, um, can you ping Mansi and them that we start with at, let's say, 5 minutes
Yeah,
later? So
I'm in touch with them, Mayank. I'm constantly having conversation with them.
Okay. Hi Himanshu. Hi Aishwarya. I think I have the virtual background set up.
perfect, perfect, perfect. So I think I should have took a small break to get a cup of coffee or tea, I guess.
No, no, we are live, by the way. We are live.
Okay, okay, nice.
Great.
Okay. Good afternoon, everyone. Thank you so much for joining us today. A very warm welcome to all of you. And today's webinar basically focuses on the draft Digital Personal Data Protection Act that has been released recently. I'm Aishwarya, and I will be the moderator for today's session. So, to our live audience, thank you for taking out your time and joining us. So, feel free to ask any questions. You can put your questions in the comment box, and we will make sure that it get addressed as many as we can. We can get it addressed. And for today's session, we are thrilled to have two accomplished experts with us today, Mr. Lalit Kalra, cybersecurity partner at EY, and Mr. Himanshu Gautam, CEO and founder at GoTrust. Let me invite our speakers to introduce themselves. Mr. Lalit, we'll start with you. Could you please tell us a bit about your journey and expertise for the sake of our audience? Thank you so much.
Thank you, Aishwarya. A good afternoon, everyone, and a very happy new year. The start of the year has been exciting with the rules coming in for public consultation. About myself, I'm a partner with EY Technology Consulting Practice. I focus on cybersecurity with specific interest in data privacy and data protection. I've been doing data privacy for last almost 8 years now, and I lead data privacy for EY in India, Africa, and the Middle East. The During the last 8 years, we've helped clients mature their data privacy journey across from doing a gap assessment to implementation and then the automation pieces. What we've to an extent we would be talking about. Today's webinar, we would primarily focus on the rules and what could be the challenges and what could the organizations look forward to from an implementation perspective. Thank you.
Thank you so much, Lalit. Over to you, Himanshu.
Thank you. Thanks, Lalit, and Happy New Year to everyone once again, basically. So, myself, Himanshu, I'm the founder and CEO of GoTrust, and we are helping a lot of customers across the globe to manage their privacy related concerns and also make sure they're compliant with the global standards, basically. And now, like Lalit mentioned, the draft rules are out, so we are trying to help the customers to assess, basically, even in advance, that okay, what are the implications they need, basically, to comply to these kind of regulations, and also next to that, what are the nitty-gritties of consent, consent managers, and when we talk about it further more in more technical way, how we are facilitating and making sure that companies are compliant to it. So that's my background. I was CTO, CIO long term, and now I'm the founder of this company. Thank you, everyone. Back to you,
Thank you,
Ashwarya.
Himanshu. Thank you, Lalit. So, Lalit, the DPDP rules have been a long awaited step towards strengthening data privacy, right? So, could you please share your initial reaction to the rules? I would really love to know what was your reaction. And for the benefit of the audience, could you give us a quick and simple overview of these rules, like what they aim to achieve basically?
Okay. So when I went through the rules over the last 1 week, the first reaction from an anticipation perspective was we would be getting a lot more details into what some of the nuances that we were looking forward to. But when we went through the details, it is meeting expectations, but not 100%. The some of the nuances, such as who would be a significant data fiduciary, because that's one of the questions that organizations have been asking, whether I would be categorized as a significant data fiduciary or not, and that is still not clarified. The other was cross-border data transfer. So some the rules have tried to walk a path, but they've not met the or not reached their goal 100% is what my first reading of the rules say. But it's a welcome step towards, it's a one step closer to data privacy for India.
Yes, at least we have something now that, like, at least we can, the organization can adhere to these rules in order to comply with the
Absolutely.
privacy
It gives
rules.
clarity on certain aspects on notice, breach, and other. It gives clarity on those.
Yeah, correct, correct. So Himanshu, you have seen a lot of businesses across globe. I would really like to know from you that, like, what was your first impression, and what was first your reaction when you saw these rules, and how, what do you think that how these rules will impact businesses, especially in India? Himanshu, you're on mute. If you can
Sorry.
unmute yourself.
So thank you, Ashwarya. So what I was saying is, you asked two questions. The first one is, any rule passed out on the global scale, always have certain ambiguity. Certain people, certain businesses have more clarity, certain don't. Sometimes rule is applicable or inclined towards specific industries versus others. So That's always the case, and I believe that with the first consultation and second, and maybe there'll be second, and then these draft rules will be more, detailed based on the feedback which Indian citizens and other business houses are giving back to the government. So that's one part. Second is one thing which globally, which we saw is even with the GDPR. So living and working in Europe for last 20 years, what we saw when GDPR came in, right? Initially, businesses were just very casual with consulting about it, and making that they have to do something, but not really what has to be done. Now, after 6 7 years, when you see even a small business house, right, if they want to sign a contract, they want to become a vendor or become a client, they in the both cases everybody is asking for an ISO certificate, for example. you know. So that's the level of impact which these rules will bring in, and this is not just a data security or some other kind of question. This is more of a hygiene question. How good you're organized structurally within your own organization, how good policies you have, how you're safeguarding the data sets basically within your ecosystem. So those are the few observations which I think will happen across the the Indian landscape across. First impact will be with larger companies with specific banking and financial and direct to consumer, or let's say D2C or B2C companies, because there is the most data. And then second wave will be for the companies which are more of on the manufacturing, and let's say which are less involved with the end consumer. So that's something which I see how it's happening. But yeah, uh, the background is that we have learned a lot from GDPR, that, and now we have already seen the journey, how and what has happened there. After that, we have seen how the global landscape changed, how multiple laws across the world came, and now when the Indian law is coming out, so I believe adoption will be very fast versus what has happened in the past, basically. So back to you, Ashwin. Lalit, you want to add something on it?
No, no, I'm good. I'm good, Himanshu.
Okay, okay. Ashwin, back to you.
Thank you, Lalit, and thank you so much, Himanshu, for your concise overview. So, since you talked about GDPR, so these rules are also introduced at a time when data privacy is a global concern, right? So, Lalit, my question to you is that how do they compare to frameworks like GDPR? Are we in line with GDPR, or are we still we need to do a lot of things in order to be in line with GDPR? What is your view on that?
Okay, so I have a different point of view on this, Aishwarya. Although the world perceives GDPR to be one of the gold standard, but I believe, and this is what I tell my client, GDPR is one of the laws which is present globally, and it would be wrong for a country like India to compare its laws to a law which has been existing in different countries globally, specifically GDPR, because they already had UK DPA. They had DPA since 95, and after that they released GDPR was released. Now, comparing our laws specifically and directly to GDPR would be wrong. Having said that, when you do a comparison between the two acts, and this is, I'm talking about 2023, when the government released the act, and when we did meetings with Mr. Ashnavi Vaishnav, there was a lot of clarity on what was the thought process in cutting short the law, making it simpler, concise for the organization. See, scale and the vastness of a country like India cannot be compared. We have smaller businesses, we have conglomerates. Both of them need to comply with the same law. And a law like a GDPR would not, for them to comply with something like a GDPR would not be fair. You would need to give some leeway to the startup ecosystem. You would need to give some leeway to the conglomerate as well, keeping a fine balance. So therefore, when you compare both the laws from a technical perspective, I believe that the India DPDPA matches up to specific needs of India, and from a technical and organizational perspective, there are certain aspects where it drives inspirations from GDPR, but it has its own, what do I say? aura which it would be carrying forward and help India become a more secure and safe data safeguarded economy.
Just two one pointer from my side. I totally agree. So on this part, that country like India, or not India, but any other country, when they design their laws, they are more intrinsic towards their own needs and challenges which they have in the country. So uh, what we, at least my point of view, what we have seen across the globe is how these rules and regulations have changed the behavior of the industry, like the hygiene factors. So those behaviors will change, but of course the nitty gritty of the law is more towards the country itself, and then how the country's data protection board or some other responsible parties, how kind of what kind of regulations they impose, that's more specific to the country. But the behavior of the companies, or the, let's say, overall maturity of these companies will grow definitely, because the hygiene factor will come into play. Whether it's whatever kind of rule it is, the hygiene is going to go up, and that is good for India from data security, data protection point of view. Because sometimes we used to have data collected at let's say people asking for a phone number at a booth where you are going to buy anything, and then if you don't give them, they will ask 20 more questions. So those kind of rude things will change. Those are nitty gritty, very small factors, but they will change. And then, as a country, I believe there will be another robust system which going to govern these processes, and we're going to mature from there. So that's what I believe will happen. Yeah, Lalit, you want to add anything on it, or?
Yes, absolutely. To just to add on to what Imanshu said, it will the obligation is, if you look at the law, the obligation on data is on data fiduciaries, but at the same time, what and looking at all the initiatives that are being run by the government and different bodies on how do you safeguard yourself from cyber crime, I'm sure there would be a wave which would enable and make people more aware about what data privacy is and what do they need to do to ensure that their data is not misused. So it's a lot more, as a India as a country, culturally, it will be very it will be a long journey for people to understand what does data privacy mean, or there such a term called privacy, because if you go to rural India, the term has a totally different meaning versus an urban India where the term will have a totally different meaning. So culturally, bringing both the worlds, rural as well as urban, will be a responsibility on the organizations as well as the government to make people more aware about what data privacy is, what are the rights that they have, whether it's respect to what is consent. So there will be a lot more effort to be put on with respect to awareness for data principles, and that's where the two laws differ.
Yes, absolutely, absolutely makes sense, Lalit. So, since we are talking about consent, so the rules also emphasizes consent as a foundation. Um, just a question on this aspect: how can businesses ensure they are collecting, managing, and storing consent effectively? Because in the rules, there are certain criterias for the consent that has been there. Like the consent should be specific, granular. So, according to you, how do the businesses will manage to store the consent effectively? Because there are different kinds of businesses that are persisting in India. There are small scale size businesses, there are big businesses. So how will they be able to manage the consent effectively, Lalit?
Okay. Thank you, Ashwarya. So, if you see, that's a very valid point that you brought in with respect to consent. And want to highlight one of the points that is mentioned in this slide over here, consent managers. So, there are two parts to it. So, you will have smaller organizations, you will have larger organizations. How an organization maintains and manages consent is essentially a user or a data principal comes onto their website or an application. They agree for the organization to collect and process their data in a particular way for a particular purpose, for a specific. Now, the law is asking organizations to give a notice at the time of consent. The notice needs to be itemized in clear and clear cut language for what would be the purpose, for how long will the data be retained, and so on and so forth. So this is these two go hand in hand, consent as well as notice. Now, once the data principal gives its consent to the organization for processing their data, what the organization does is in the typical in a ideal architecture, I mean, irrespective of whether an automated platform is being used or not, they would flag that consent in their particular database, and then ideally use that data for marketing and other purposes for the specific purpose. Now it is, and the same goes when the individual withdraws his consent. But it is easier for an organizations or large scale organizations to run and maintain this. But for a smaller scale organizations wherein they will not be getting too many consent requests on a regular basis, that's where the role of consent managers and the role of SaaS based platforms comes into picture. Wherein they do not have, wherein they can a liaison with the consent manager who would do and manage consent on their behalf, giving them data interoperability and doing it on their behalf. The other would be organizations can utilize services of SaaS-based platforms like GoTrust, OneTrust, and the other pieces, wherein the automation for specifically a modular automation can be done, and they can instead of managing the whole process on their own, the organization can use these to run this as a managed service and run consent as a one of the services. Himanshu, you would want to add on this, I'm sure. Himanshu, you're on mute.
I was listening across and I was saying that you're perfectly correct on it. So I was just want to pass this question and give the comprehensive collective answer to the next one when we move forward. Right. So I totally align with you on this part, and then we'll add more in the
Perfect.
next round.
Yes, thank you so much, Lalit. Himanshu, so since we are talking about consent and how the consent should be, and how the organization should be dealing with the consent requirements, so how does GoTrust play a role in this consent management, and how can it help businesses simplify the process? Would you like to add something to it?
Yeah. Uh, when we talk about consent, right? Consent in the context of DPDPA has multiple phases, right? So we're taking a consent from a customer where it's a parental consent. So DPDP has came up with a specific rules, guidelines on this part. So when we're talking about, if we go normal consent like, cookie banner consent, or it is more of a product related consent, or it's age related consent if you're a minor or not, multiple different detailed, let's say, rules has been laid out. Of course it's in the draft, but still if we go more focus on the consent for the minor part, because that is more of a concern or discussion within the Indian context. uh, Multiple things are possible there. So some of the example were mentioned that we can have an Aadhaar based consent, right? That's one of the most easy thing. For other ways, there are many third parties in India who do ID verification. So we can take some APIs from them and do that kind of consent verification for the consent. Then many companies are there in India doing KYC. So they already have certain ways for the banking sector to do the consent. They can also do the consent basically for the verification part. So there are many ways how the consent can be played role. Question is how a platform can facilitate this. So then, so our platform is specifically, if I speak from Gota's point of view, there are many ways. So you can design the web forms, consent forms. There's been many facets to it. That you can have API based consent where the customer or you are the middleman for collecting the consent and making sure you have a golden data source for all the consent which has been collected. And so on and so forth. Basically, there is another way you can collect consent. If no, we talked about the laws and then we think about the future. Just imagine what about all the consent collected from the past, so all the historical consent, and how good they're compliant with, basically. So that's another way to look at it. So we as a platform facilitate all the three means, whether it's the future consent, current, or the past. and we provide more than 200 odd integrations to integrate, whichever source you are using. And see, the goal of collecting consent is to make sure the company is compliant, and then they are doing all their marketing and other activities in a more efficient way. So that becomes very interesting because half of the time when I talk to a lot of customers across the globe, they are more worried that, okay, if we are going to follow this strict regime, we cannot do the marketing. That's one of the bigger concern, how we'll get more customers. And the contrary to this is when we are basically applying these rules, we are becoming more authenticated. And once we are more authenticated and customer loves that company more versus an arbitrary company who's asking for a consent or not asking for a consent in that case. So the trust is becoming the biggest factor in the new gen, basically. Doing and applying these complex consent rules helps company to grow, and then also brings a lot of trust within the end customer. So that will be my state on it. And then we can go to the nitty gritty, of course, Ashwarya, as and when you ask the questions. But applying consent will bring more business to the business houses. That's what my stake is. Yeah.
Oh, thank you so much, Himanshu. That was a great insight to the GoTrust platform. So before moving forward, we have a couple of questions from Sumit. He's asking that what rights do individuals have under the DPDP rules, and can individuals withdraw their consent for data collecting or processing? So these are two individual questions. Lalit, would you like to address the first one? What rights do individuals have under the DPDP rules?
I'll take the second one first because that's a
Okay.
quick one. So, Sumit, yes, the individuals can withdraw their consent for data collecting or processing. And that's the whole objective behind the consent framework is that the rules also state that withdrawal of a consent should be as easy as it is to give a consent. So that's one of the key areas that the government and is focusing on when it comes to consent. And with respect to rights, there are several rights that a data principal gets. It starts with the right of access, wherein the individual can request the data fiduciary to share what kind of personal data is being processed, where is it getting shared, and what is the purpose for which it is being processed. That is the first. Then they have right to correction and erasure, which essentially means that that an individual can get their personal data corrected or erased depending on the law of the land or if there is a legal obligation which is applicable. The third is the right to grievance redressal, which essentially focuses on the fact that an individual should, in case the organization or the data fiduciary is not able to meet the data principal rights, they should have an obligation of option to go for a grievance redressal mechanism, and that is one of the rights that the individual gets from a perspective. The last is right to nominate, and this is what differentiates the act from other global laws that we have. Individual can nominate in case of a death or a disability someone else who can manage consent on their behalf. None of the laws globally have this provision of right to nominate for the individual available. So these are the rights which are available to the individuals.
Thank you so much, Lalit. We have a follow-up question as well from Sumeta Garg. She's asking which company is required to appoint the consent manager. Are we having any specific guidelines on that in the rules?
So the rules do not specify which company is required to appoint a consent manager specifically. Uh, the rules have given obligations of a consent manager. The rules have given who can be a consent manager and who cannot be a consent manager. But it would be up to the organization or the data fiduciary whether they want to utilize the services of a consent manager or not. In fact, this is one of the gray areas that we would need to be clarified with the in the public consultation is whether the consent manager's role is required to help in interoperability, and they have given certain instances or examples with this by taking certain examples. But as one of the technology companies, if I am processing data of individuals, it is not I have automated platforms, I can manage consent on my own. But there is another organization which is utilizing the services of a consent manager. So how would those two merge together and work interoperably is one of the questions which is not yet answered, but it is not mandatory for an organization to appoint a consent manager.
So uh, I would add a point here. So perfectly, as what Lalit said, just a small addition to that. So mostly like bigger organizations where there is a significant volume of personal data is handled, because there is the situation where the risk is high. So normally, that's how it goes. That's the volume is high, risk is high, and then you need an independent party who's gonna manage or help the organizations to stay independent and help them in multiple aspects, basically. And therefore, you need a consent manager to make sure that the company is making sure they have high level of compliance. They have created an enhanced user experience, for their customers. So whenever there is an issue, there's somebody to go. And then they've also uh, how to call it, it also gives a persona towards the consumers that this company is really thinking about data privacy and data security. So it's also a posture management for the companies, and how they look like, how their persona is, that because they have taken care of all the aspects of DPDPA, and even the ones which are not very clear yet. Now I go with Lalit's comment that maybe in the second or third version of the rules, these things will be more detailed, basically.
Yes, thank
Yeah.
you so much, Himanshu, and thank you, Lalit, for addressing the question so perfectly. Moving ahead, we know that the draft rules include certain exemptions for small entities as well. And like Lalit, I would like to know from you that what are these exemptions and whether they are sufficient to support small businesses or not. The exemptions that are mentioned under the rules.
So if you look at the exemptions, Aishwarya, and that is what we have on the slide as well, the exemptions are not specifically with respect to a type of business. Those are specifically related to the type of purpose or the type of service being utilized. So, for example, the key as a exemption that they've given is for research, archiving, or statistical purposes. This is specifically considering the purpose because you would need data for research, archiving, or statistical at a country level, at an economy level. So that is one of the exemptions that is given. Education, healthcare, and child services. Now, these exemptions are specifically related to children data processing. One of the larger concerns that the industry had was you have tons of schools and educational institutes and healthcare which are not much digital savvy. How do you get them to get onto this journey and ensure that the data that is being processed with respect to children, because they have huge amount of data, a huge amount of data which could impact the mental health of a child, and the specific requirement on verifiable parental consent is one of the exemptions for these specific scenarios: education, healthcare, and child services. So that's the another exemption. The last exemption is government access request. Now this is a gray area specifically when it comes to the exemptions, whether the government will be fully out of the purview of the act, or whether the whatever work that the government wants to do, can they find out some loopholes in the act and then process the data.
Um, yes, Lalit. So we have a question on that as well from Rachna Shroff. She's asking that how will these law impact companies which are in media and entertainment and customer acquisition cost as well.
uh, so I if you look at it from a specifically whether the law actually increases the cost or decreases the cost, now that will depend from company to company. But at the outset, if you would see any change in a particular regulation or any change in a particular way the business is being done, then the company would have to undertake and look forward from a impact perspective.
Okay. Thank you so much, Lalit, for answering that question. So we can move forward.
Shreya, I would like
Himanshu,
to add
yes,
one
yes, yes,
impact,
yes, please.
one pointer on that one. So, irrespective of,
Uh,
yeah, Lalit, you're saying something?
no, I think there was a network blip when I was
Okay.
answering that question.
Please go ahead. Please go ahead. Yeah.
Okay. So what I was saying is whenever there's a change in a regulation, there's always an uptake in cost wherein the organizations comply with the newer requirements. But over a period of time, the cost normalizes, and the customers are able to see the benefit of an organization which is high on privacy versus an organization which does not take the data privacy seriously. So that's a cost arbitrage that the companies would have to undertake and look forward from an impact perspective. But it is the law. It is the law of the land, so organizations have to comply with it.
True, and that's what I was also going to add here. So you are perfectly mentioned already that looking at the global, purview, applying this. So there's definitely in the initial phases, it looks like the cost has gone up. But if you see the long-term impact of such regulation, so I can give you the live example of my past organizations where we implemented GDPR and other regulations. Uh, so before my GoTrust life, and when I was implementing other tools for my own organization, initial cost seems to be bizarre, but the output or the end result which it brought was the structure, the policies, everything in the company, which helped us to streamline all other processes. So all the compliance and legal related matters were more smooth, so we needed less people to execute it. So at end, y- but basically what happens is if the business grows, all these needs grows, right? You need more hands to manage your ticketing system, more hands to need whichever department or whichever industry you are working in. So but those growth are all optimized basically, so the cost part of is very well optimized. So that's one thing I've seen myself happening in the organizations, specifically when data is involved. So ambiguity with the data is so much that with the structured, unstructured, how the data set is created. If the company has a history, like it's a very old organization, it's like a family house, then there has been a lot of people coming in, going out. So who has developed what kind of software and how the data is stored, what level of security is implemented. Now everything is at big risk, which is not known. And with these rules, we have to follow, and we have to make sure that we reach to a standard, a baseline standard, which everybody else is. It always benefits you. And so initially it looks like it's a cost, but in the long run, it is going to be a lifesaver, basically, which will be protecting you from the threats, basically, and many more things which going to come, which are not seen yet. So those things. So that's a live answer I can give, live example which I have seen myself. Yeah. Then
Thank you,
going back to
Himanshu.
you, Ashwarya. Yeah, back to you.
Yeah, thank you so much, Himanshu. So just a follow-up question on this one, Himanshu, that like what we discussed right just now. We know that compliance can be daunting, and especially for small businesses. So how can GoTrust make it easier for the organization?
I think for us, what we have done, looking at the Indian customers, looking at the Indian landscape, we have customized solution. It's pre-ready to be consumed, so you don't have to have a solution where you have to come hire for other consultants to adopt the solution for your company. So we have already templates. We have already created certain aspects of industry specific. Uh, I don't want to use templates, but let's say industry specific guidelines, pointers, which you need to adhere to. So whether it's entertainment industry, whether you are, uh, financial sector industry or manufacturing, for example. So we already have designed our solution accordingly. So we, once you on board, so 80 to 90% of the solution is already ready for you to be consumed. Only last 5 to 10% you have to adopt, because every company has their own DNA. For example, a role in one company might be called IT manager, another they are using a Spotify model where it's called Tribe Manager. So those small things which you need to adopt. For the rest, the tool is already ready, and it's developed in India, so it's Make in India tool. So we have a Government of India stamp, NASCOM stamp is there. So it can be adopted, trusted very easily because of all the validations. It's certified, ISO SOC 2 certified tool. So those things also brings the companies and the compliance team an ease at their end, that okay, this tool can be adopted and implemented very fast. Yep. Then back to you, Ashura.
Thank you so much, Himanshu. So we also know that the rules are not comprehensive enough, and it's not giving a clarity actually on the DPDPA. So Lalit, would you like to address on the challenges part when it comes to
Aishwarya,
implementation?
sorry,
Yes,
sorry to there are
yes,
two
yes.
questions which are very good ones before we move forward. I think the
Okay,
first
yeah, yeah,
one
I can
was
see
from
that.
Rachna, which was about the cost of implementation on specifically on the media and entertainment. So Lalit, would you like to take on that one? So how, what will be the especially the impact on the media and entertainment house? On the cost side means what's
So
going to
I
happen?
think that is the question that we addressed, Himanshu, earlier. That whenever there is a new law, there's an initial uptake in the cost, but over a period of time, it normalizes. Whether it is a media and entertainment company or a quick commerce company,
Yeah,
both of these companies or any e-commerce company, I would say, not even quick commerce, any e-commerce company which relies on B2C perspective would have to initially im- take in some capex to build a framework to automate their ecosystem. And then as the operations stabilize, as the data privacy journey matures, the costs typically are considered as part of the compliances cost and then normalize over the years.
yeah, true. But I'm reading this question now as from another angle, because the last one is also very interesting to see customer acquisition cost, right? So one is the implementation cost, which we answered
Yeah.
very well, and I thank you for that, Lalit. But then at the same time, it goes to the customer acquisition part. If the laws are very much strict, you cannot do a lot of marketing on the cookies part. How will you acquire more customer, right? And this is very interesting question because. If I look at it from the GDPR point of view and from the European and other context countries point of view where the laws were implemented and how it was observed by business houses, I think answer was, I think we discussed in the beginning, which trust is the biggest factor which will come into play. If you can bring in your company as a trustworthy, nobody has a problem giving you the consent. And if the trust is missing, a lot of customers will not comply or not signed up for your product basically. So that's one of the 2 cents which I can add on top of what Lalit mentioned from customer acquisition point of view. And yeah, of course you can
Absolutely.
relate.
Yeah, absolutely. As a customer, I would be more inclined or feel safer giving data to a company which has stronger data privacy processes versus a company which does not have. So overall, while the initial customer acquisition cost may go up, but the companies can charge premium.
True.
So that could be another way to look at it.
Yeah, yeah. Perfect. Thanks, Lalitam. Yeah, that's also another angle. Ashwara, will you take the other question? Yeah, perfect.
Yes. So the other question is how DPDPA impacting GCC, that is Global Compatibility Centers established in India.
Okay, so so all the GCCs that you would have in India. So GCC is essentially one of the officers capability centers that MNC has. Now, their primary headquarters would be majorly out of India. They could be across Europe, Americas, or wherever they are based out of. So they are anyways complying with that law of the land, whether it is GDPR or any other law. So their headquarters and to a large extent the offices in India are also compliant. But where it impacts GCCs is, and this is what we've seen with a lot of companies, they've wherever they have to comply with the law of the land, they've done the implementations to those officers. So when it comes to the Indian Act impacting GCCs, so there are certain things that they would have to do. A, they would have to update their global frameworks to comply, to take into consideration the requirements for from DPDPA also. Secondly, when they are on the journey for implementation, they would have to ensure that they are the data fiduciary for their employees. They are the data fiduciary for their vendors and data processors. So all the contracts that they would have signed with the data processors, those would have to undergo a change. The employee consents programs will have to go undergo a change. See, you will have to see. Uh, a lot of the other laws give a huge emphasis on legitimate use,
Yes.
while in India it primarily relies on consent. So the changing of the framework would need to be done in a thought through manner, wherein consent be for India becomes the primary lawful basis of data processing. So that's one of the changes that the GCCs would have to do, and extend all the global practices specifically to India, so that the Indian GCCs comply with the law of the land. So those are the specific nuances, whether it is appointment of a DPO, registration of the organization with the data protection board, some representative who can answer on behalf of the organization, and so on and so forth. So these are the specific nuances that the GCCs would have to take care of.
And Lalit, if you add up, also on one more topic is today when the data was coming to India, right? All the test data and all the data which used to be processed in the back office in India. So I think there is also impact on the cross-border data transfer, right?
So it's the other way around, Himanshu. So the law as of now is the rules as well as the act is silent on the rules on cross-border data transfer. It says that for when the government defines which type of data can go out and which type of data would have to stay in. So, for example, for critical services, they are saying that the data would have to be stored in India, can be processed outside. But for a GCC, it is a lot of data from outside comes to India. The servers might be for the data, the Indian data principal data might be processed outside, but will have to be stored in India.
Mm.
This we'll have to wait and watch on what kind of data can go out and can need to be stored in India. But this will be one of the key aspects that we would have to watch out for.
Okay. Good. Thanks. Thank you, Lalit. I'm also learning. So thank you.
Thank you,
Yes.
Lalit. Thank you so much, Himanshu. So we can proceed forward and cover the challenges part in the implementation concerns. Like Lalit, according to you, what are the challenges that we have in the rules that have been out? So it is not giving a clarity actually on various aspects. So according to you, what can be the possible challenges that the organization would be facing in future when it comes to compliance with the privacy regulations? And
So I would
also,
not call. Sorry, go
yes,
ahead.
yes, please go ahead. So actually, you can also cover about the significant data fiduciary part. This is one of the question put by Shweta Garg, because significant data fiduciary part is also a kind of ambiguous in the rules that have been provided to us. So please go
Correct.
ahead.
Yeah, so I would not call those challenges per se, Aishwarya. But I'll first take Shweta's question on significant data fiduciary. So, from a significant data fiduciary, the only clarity that we have in the rules is that they mentioned the time period for doing the DPI and the audit to be 12 months. Otherwise, it is similar. All the other information is similar to what we had in the act specifically. So there is still a clarity missing on who would be categorized as a significant data fiduciary and the additional obligation that they would need to do. They whether the DPIA needs to be done internally or whether the DPIA or the audit needs to be done externally. Those are some of the eight clarifications which are still missing with respect to significant data fiduciary. But this is one of the areas that the government is vocal about, and when the public consultation and the further versions of the rules, I think we should see some clarity on who would be categorized as a significant data fiduciary or when they are notified to be a significant data fiduciary.
Correct.
Okay.
Thank you.
Now the other question that you asked, Aishwarya. So I would not call them challenges per se, but those are the things which are still unknown from a perspective of rules. So first is the significant data fiduciary that we talked about. That who would be categorized as a significant data fiduciary. The other point is on consent managers, whether the consent manager has to be a internal, external, although they've talked about conflict of interest per se, but that's another area that is needing some clarification. Now, from a notice perspective, the rules have given the that it needs to be itemized and other aspects, but the timelines for retrospective notice are missing. The all the data that the organizations have already collected, who have already given their consent before the commencement of the date of the act, what when do I give them notice? What is the time period that I have? So that is another piece which is missing. The in how much time do I need to respond to data principal rights? That's a key piece which is missing because GDPR talks about 30 days. We've still not received the timeline, and at the same time, we have the data grievance part wherein the organizations have to have put a grievance redressal mechanism in place without the timeline that we are yet waiting for. We talked about cross-border data transfers, so that's another piece which the clarity would be required. The startups, as per the startup act, there is a definition of startup that are need to be considered, but the threshold for volume, nature of personal data, class of data fiduciaries who are exempted from specific obligations needs more clarity. And one of the key aspects which the I believe needs to be taken into consideration with respect to is the special categories of personal data. Although the Act is silent on special categories of personal data, but that it'll be interesting to see how that is taken care of in the rule. So those are the some of the still unknowns rather than the challenges, Aishwarya, that we believe.
Yes, Lalit. It seems that we are still waiting for the for clarity on these parts. We have a follow-up question again by Shashank Mohan. He's asking whether consent manager has some accountability as compared to the fiduciary.
Yes. So first is there has to be there should not be any conflict of interest between a consent manager and data fiduciary. Second, the consent manager also acts as a data fiduciary for the data principal that it is serving. And since it has to register itself with the board, there are specific obligations which are maintained for consent managers, and they have to comply with all the other obligations from a data fiduciary perspective also. So consent manager has to comply with the all the obligations of data fiduciary.
Okay, thank you, Lalit, for addressing that question. We can move ahead and Himanshu, if you would like to address the key features that GoTrust has when it comes to the newly identified aspects that are involved in the DPDP rules. How does GoTrust comply with all the aspects that are mentioned and that are essentially required? Can you please enlighten us on those parts? Thank you so much.
Definitely. So, first of all, thanks, Lalit, for clarifying because hearing you out also, I'm also learning a bit on the stage now. So, yeah. So, the goal of the GoTrust is to take 360 view of the challenge, which is we call it DPDPA, the implementation of DPDPA, and we make sure that not only the companies have all the modules, let's call the modules, to comply with the law, but also how fast you can implement it. Because there are twofold challenges. Number one, do you have all the weapons to fight a problem, and then do you have how quickly you can assemble them and make sure you're ready for the challenge. So with GoTrust, what we are trying to fight these two challenges at the same time. Number one, like we already talked about, we already have pre-configured templates, pre-configured industry specific solution. So if whichever industry it is, we have did quite a good job in mapping it and learning from global experience, right? So that always helps us to make sure that experience from different geography helps us to cover up those kind of challenges. So we have done that. And then when we go to the specific module specific part, what we have is not only doing your ROPA assessments basically, so from cookie consent, from consent and preference management, from data mapping, from DSR response, from assessments, basically like your PIA, LIA, TIA, we talked about cross border. So we have all those templates already ready. And then, of course, some of ambiguities are there. So with the time, these will mature, and with every organization has an opportunity to update, modify, or upload their own templates if they have. So those are the flexibilities tool provides. There is vendor risk management, compliance automation, assessments, data lineage, under data discovery. A lot of factors are there, which tool is providing you to fight the challenges basically. And then we have a breach management basically. So now you see how important the breach management is under DPDPA, which clearly explains the timelines for what has to be taken. So those all angles and aspects has been covered by the tool. So we make sure that you have 360 purview of DPDPA, and then you can see the assessments. You have audit frameworks for auditors. So how far you are with audits. We have done the first audit, and then for the second audit, if there are certain red flags, so how you have managed them, what you have done in your ISMS meetings, and so on and so forth. Everything is recorded, and you have at full scope at one place, so you don't have to have multiple solutions to cover your DPDPA. That's our goal basically. Of course, we are also learning, to be honest, and also we are improving the tool as we speak. Every time we learn, like today also I got a lot of enlightenment from Lalit, so we're going to implement those very quickly and immediately in the solution though. So from a standpoint that we say we are holistic solution, and yeah, we can help the kind of organizations to cover DPDPA challenges, and also in a faster manner, not in a very slow or ambiguous manner. So yeah, back to you, Ashwara. So that's what we are.
Thank you, Manju, and thank you, Lalit, for breaking down these complex rules into simple and actionable insights. Actually, it was a learning experience from me, and I'm sure that the audience have learned a lot from this session as well. Thank you so much, audience, for your active participation. We hope today's discussion gave you a clear understanding of the DPDP rules and their implications, basically. So stay tuned for more updates. And till now, please stay safe and take care. Thank you so much, Lalit, and thank you so much, Himanshu, for joining us
Thank
today.
you.
Have a
Thank
good day.
you.
Have a good day.
Thank you, Maju.
Thank
Thank
you,
you,
everyone.
Ashwin.
Thank you.
Thank you,
Thank you,
everyone.
Lalit. Thanks. Bye.
Thank you. Bye.
Thank you. Bye bye.